Matter in which I prepared a written judgment. Order 1. The defendant is liable for the plaintiff's proven or agreed damages. 2. The defendant is ordered to pay the cost of suit. I hand the judgment down.
In the matter between Janusz Walus and Minister of Correctional Services and the others, case number 4182 of 2015.
Mr. Murani.
May it please you, my lady. I appear for the applicant for leave as the first respondents before your ladyship, together with my learned colleague, the best.
Thank you.
May it please you, my lady. I appear in the application for leave to appeal on behalf of the respondent and in the Section 18.3 application on behalf of the applicant, together with my learned friend, Mr. Kellerman, who is only waiting for his letters of patent still.
Yes, thank you.
Third and fourth respondents in the agent application. My lady Malindi. Yes, my lady. For housekeeping purposes, my lady, we filed the third and fourth respondents' answering papers yesterday. I have in my possession the originals and I beg leave to hand them up. My learned friend, Mr. Duplessis, says he has no objection to the papers forming part of the record in this meeting.
Yes, that is correct, my lady. My lady, may I also ask to hand up a signed decline affidavit? We sent an unsigned one to your clerk, my lady, but that is the signed one. And then, my lady, before my learned friend, Mr. Murani, continues, I would like just to move for the amendment to the notice of motion, which is in the papers on page 59.
Only pertaining cost.
To cost to council. That's the only basis, and I don't believe there's objection.
No objection.
Indeed.
No objection, my lady.
Thank you. The amendment as prayed for in the applicant's notice of intention to amend, to wit, amending Pre 3 to read costs of suit to include the cost of two counsel is granted. Thank you. Yes, Mr. Murani, there's an application where you appear for the applicant,
Yes.
and then there's the application by Mr. Duplessis.
Yes.
Would you prefer, let's first deal with the application for leave to appeal, because it would not be fair to you to answer to an application that Mr. Duplessis is bringing. Is that correct?
And in any event, Millennium Friends application is dependent upon the application for leave to appeal.
Indeed.
So that has to be
Adjudicated upon first.
that is so.
Thank you. Mr. Murani, I have perused the grounds of application for leave to appeal. I just want to get one or two aspects clear before you proceed. Section 6, I'm referring to PAJA. Section 2H does refer to administrative action that needs to be reasonable. Is that correct?
Yes.
And the empowering legislation would be the parole guidelines. Is that correct? Or may the minister take a decision in absence of any of the legal, the legislation?
The legislation, milady, would firstly be the new act, the old act, and the policies and guidelines.
Yes. Now, I just wanted to make sure. So the minister's decision should also be informed by the policy and guidelines. Is that correct?
That is so.
Thank you. You may proceed.
That is so, yes. Lady, at the outset, I wish to place a historical fact before your ladyship. And that historical fact is that 2 days ago was the 23rd anniversary of what we regard as a brutal and senseless murder of one of the finest sons of South Africa by Mr. Janusz Walus, the respondent in this application for leave to appeal. Now, that murder was described by the judges that heard this matter.
The judges in the local division or Supreme Court of Appeal?
Both.
Both.
In the court at Ko, the description is at page 44.
Was that the Judge President Eloff's decision?
That is so.
Yes, you may proceed.
Yes. Where he deals with sentence, because I shall address your ladyship about the sentencing remarks to a very large extent, so I think we should put this in its proper perspective. At page 44, line 20.
You're referring me to the application now?
I'm referring to the sentence remarks.
Yes, but where do I find it in the record? Where do I find it in the record before me?
Page 44 of the record.
Thank you.
Of the 53-1 record.
Yes.
That's where it's to be found, lady.
Yes, thank you.
Yes. And these are the factors on which the assessors and I agree that a number of factors which are mentioned, that firstly, that the accused conspired and took part in the planning of an act of assassination of a person who had attained prominence in the public affairs in South Africa, whose killing was likely, to the knowledge of the accused, to cause far-reaching, highly emotive reactions with extremely damaging consequences and very harmful effects on society in South Africa, and also to have a profound effect on political matters.
That was indeed a position in 1993. That was indeed the position in 1993.
Yes. But I'm dealing with this, my lady, in the context of the guidelines, which enjoin whoever is considering parole to take account of this. Yes.
It is one of the factors to take into account.
Not only one of the factors, my lady, but we shall argue that her ladyship did not regard this factor as of the utmost importance. That is the point that we are making.
So you argue that this factor is of the utmost importance.
Precisely.
The other factors, are they of lesser importance?
Well, certainly no judgment has ever said that the other factors are of the utmost importance. The full court, this division,
yes,
has held that these factors, nature of the crime, sentence remarks, are of the utmost importance. That's
yes.
incidentally.
Kindly refer me to that case law you're referring to.
Darby Lewis.
Yes, and the citation?
My lady, it's in our heads, the heads that we. I'll find the reference just now. 2009.
2009.
6, volume 6.
Yes.
SA.
Yes.
205. Not Gauteng. At 218B.
And it was a judgment by?
It was a full bench judgment. Justice van der Merwe, Justice Shongwe, who eventually landed up in the SCA, and Justice Severity, who also ended up in the SCA.
So it's quite a prominent bench.
A strong bench. Yeah.
Yes, and in that matter it was found that the nature of the crime and the sentencing remarks are of utmost importance.
Of the utmost importance.
More important than the other factors.
Well. I'm quoting Milady. They found that they were of the utmost importance.
Yes. No, I just want to make
and,
sure.
And our submission, obviously, will be that a ladyship, in assessing the various factors that have to be taken into account, held that the factors are of equal importance.
Yes.
Yes, we submit that was a misdirection, that in fact, in terms of the authorities, the nature of the crime, sentencing remarks are of the utmost importance. Now, if Lordship Justice Elof went on to say the assassination was planned well in advance, with ample opportunity for reflection and reconsideration. The assassination was decided upon not impulsively or spontaneously in reaction to a specific occurrence. The accused was a mature person with experience in public affairs who must have realized what widespread reactions would follow on the assassination. The accused does not appear to have shown any remorse, and so far from assisting the police investigation, to have given false information regarding the time he had last seen accused number one. Accused number one in that matter was Mr. Darby Lewis. So they are talking about Mr. Janusz Walus here. Let me just make certain of that. No. Walus was the first.
First.
Yes, first. And Darby Lewis was the second. Yes. These are the factors on which the assessors and I are agreed. I now turn to the question of appropriate sentence. The factor of vital importance in determination of sentence is that we are here concerned with a case of assassination of a person prominent in public life by reason of the ideologies which he endorsed and because of the perception that his track record was unacceptable. I'll skip some of the passages. If assassination of that sort is perceived to be an acceptable option in this country, the consequences may well be disastrous. Chaos, anarchy, widespread bloodshed, and damage to property is likely to result. The political consequences may also be fundamental. The point which we are going to make, lady, is this was no ordinary run-of-the-mill murder. It was a a murder which was calculated to bring chaos and bloodshed in the country.
To disrail the whole process that culminated in our constitution and democracy.
Yes. In fact, it's ironic, milady, that the people, now I'm referring to Mr. Darby Lewis and Mr. Walus, who were opposed to the new order coming into effect, actually benefited from this new order.
If it wasn't for the new order, they would have hanged long ago.
Absolutely. Yes.
But it does say something about our new order.
Absolutely.
Based on the principles of the Constitution, of humanity, and so forth.
Yes.
No longer in apartheid days with murder and so forth, or rather death sentence.
Yes. Well, while the accused and possibly other persons may have perceived the deceased and his ideology to be viewed with concern, if not abhorrence, many others saw him as a hero and a leader to be followed and admired. Assassination of such a man is likely to let loose terrific emotions, uncontrolled, and possibly outrageous conduct. The assassin must surely have foreseen that sort of consequence.
And that emotion is still prevalent and very alive today.
Yes, that is so. Like, just to take an example, the victims of the Holocaust, which happened many, many decades ago.
It's 1945, around 44, 45.
Yes, from 1939 and before that. 1939 and before that. Those victims still feel it even today. And the victims are still looking for and hunting for the perpetrators of the Holocaust. Even if they might be 80 or 90 years old, they still want them to face the full might of the law.
They want closure.
They
want closure.
And justice.
Yes.
They want justice and closure.
Because justice normally brings closure.
That is so. That is so. Now, on page 46, line 22, the accused could not have thought that they were in a military struggle. They certainly did not testify that they committed the murder as part of a military action. They simply arrogated to themselves the right to destroy the life of the person because of their own political perceptions. And on the following page, lady 47, for the line 12, for the accused to arrogate to themselves the right to take life of a man like the deceased, for what he represented and for what he believed in, is, as Heifer J.A. said in the case referred to be visited with a severe penalty. Now, at a later stage, I shall indicate that the SCA, in fact, considered this crime so vile that they not only said that Walus, Mr. Walus and Mr. Darby Lewis should be visited by a severe penalty, but they put it in the superlative. They said the severest penalty that the law permits. In other words, lady, they did not regard this as a run-of-the-mill murder. They regarded it as a murder which deserved the severest penalty. Then they did not say what exactly triggered them. Over and above that, they had ample time to consider and reflect. They are both mature persons, and number two, as I said earlier, is deeply rooted in politics. The position might have been different if there had been evidence before me that the act was decided upon impulsively in relation to a specific event which triggered extreme anger. I need further to stress the other aggravating factors summarized by me earlier. The murder was a deliberate, cold-blooded one. The act was cowardly in the extreme. It was preceded by weeks of planning. The deceased was felled down in front of his own residence when he was completely defenseless. And as I've mentioned earlier, none of the accused have shown any remorse. The two most cogent factors which to my mind point to the imposition of the extreme penalty are the elements of retribution and deterrence.
Retribution
and deterrence.
Deterrence.
I interrupt myself to say that the other factors bearing on sentence were all considered by me. The retributive and deterrent elements come to the fore in a case such as the present, where a man who was seen by a substantial section of the population as a leader and a hero was shot down in cold blood. In this context, I return again to the Botha judgment, and I shall not quote what was said. It's a long, long quotation from the Botha judgment. And at page 50, here too, I believe that the aggravating factors overshadow the mitigating factors by far. Lady, it is our submission that even in a case where the minister has to consider parole, he has to take into account both positive and negative factors. But if he is of the opinion that the negative factors overshadow the positive factors, then he is bound to act in realization and acceptance of that balancing.
And when would the court then be entitled, if at all, in terms of parja, to review and set aside?
Yes. I beg your pardon?
I say, and when
yes.
would a court be entitled, if at all,
yes.
in terms of parja,
yes.
to review and set aside the minister's decision, or would there never be any possibility for a court to interfere?
No, there is a possibility, and that's where, milady, the distinction between review and appeal come in.
Oh, that is why I wanted us to make sure
yes.
what we are talking about, that we're on the same page.
Yes.
We are dealing with a review.
Yes.
A review ground is whether it was reasonable. Is
yes.
that correct?
Yes.
Yes, you may proceed.
Yes. And in the review, the reviewing court must come to the conclusion that what the decision maker was unlawful for any of the reasons mentioned in Parja.
And we've now determined which section deals with unreasonable. If it's so unreasonable that a reasonable person in the shoes of the decision maker
yes.
would not have come to that conclusion.
Yes.
That is a ground for review.
It is a ground of review,
We
lady.
just make sure of that when we Yes, it's section 6 2H.
Yeah, that is so.
Yes.
But one problem with a ladyship's judgment is that your ladyship did not refer to a particular section of PAJA.
But what other section in PAJA deal with reasonableness? Remember, Mr. Morani, you will recall,
Yes.
when this matter was initially argued, I asked you pertinently, is that the issue to be determined? Because that was what Mr. Du Plessis argued. And you said to me, yes, it's whether the decision was reasonable. And if reasonableness is one of the grounds for a review, I'm not following your argument.
The argument is simply this, my lady, that your ladyship did not base your judgment solely on reasonableness, but the ladyship mentioned irrationality.
Yes.
Ladyship said the conduct of the minister was both irrational and unreasonable. In our submission, lady, is that the rationality review is different from reasonableness review.
Yes. It's two different grounds.
Absolutely.
So if I were incorrect
Yes.
in referring to rationality, but being reasonable is still a ground for review, where does that leave your application?
Yes. Well, firstly, the court would have to accept that the court, with respect, was wrong in characterizing the conduct of the minister as
Well,
irrational.
the court doesn't need to find that. The court needs to find when there's a reasonable prospect that another court will not agree with this court. Luckily, the court does not need to find at this stage that I was right or wrong. Isn't it stated simply in section
17(1)(a).
Yes, it reads, the appeal would have a reasonable prospect of success.
That is correct.
So it is not the correct principle to say that I need to find I was wrong. Luckily for the applicant, it is a far lighter principle or
Yes.
test. It's only whether there's a reasonable prospect of
Yes.
success.
Yes.
So is it your submission that the fact that I referred to irrationality, that constitutes a reasonable prospect of success on appeal?
I'll develop the argument, my lady, at this stage, because the ladyship asked me about section
Yes.
6(2)(h).
Yes.
I just wanted to point out at this stage that in our humble submission, there was a misdirection in lumping irrationality with reasonableness.
Yes.
That is the point I'm making. And the point I'm also making is that there was no justification to find that the conduct of the minister was irrational.
It's conduct, isn't it the decision?
I beg your pardon.
If you say conduct, you refer to the decision
Yes.
that was made.
Yes.
The minister may, so the minister will then be exercising a discretion.
Yes.
And that discretion needs to be informed by the empowering legislation that we've already canvassed.
That is so. That is so. As I say, my lady, the point I'm making is that there was no justification for the finding that the decision was irrational.
Yes.
I'll come to reasonableness, but at this stage I'm just dealing with irrationality.
Because if we do deal with irrationality, that would be section 6(2)(f). Not rationally connected to the purpose for which it was taken, the purpose of the empowering provision and the information before the administrator.
That is so. That is so. The point I'm making, the lady, is that ladyship did not distinguish in the ladyship's judgment between the rationality aspect and the reasonable aspect. There's no distinction, and there's no analysis of the rationality aspect and the reasonable aspect. They are lumped together. In other words, it's in one sentence. It was irrational and unreasonable, without analyzing the two concepts.
Yes, separately.
Yes, that is the point we're making in this regard. Lady, back to page 50.
Are we once again with the judgment?
Page 60, page 50 of the
50
of the Rule 53.1 record, where it says, "Here too I believe that aggravating factors overshadow the mitigating factors by far. It can be expected that not only the family of the deceased, but large sections of the community were extremely shocked and distressed at the assassination. As a deterrent, I wish, in imposing the sentence which I have in mind, to send out the message loud and clear to any who contemplates assassination of political leaders as an acceptable option, what view the court takes of such conduct." And the Lordship concludes by saying, "I conclude that the ultimate penalty is indicated in both of them." In other words, and they were then sentenced to death. That was in the High Court. Then in the Supreme Court of Appeal, and lady, this is at from page 57 of the same record.
The judge, was it Judge Corbett? Was the Chief Justice?
No, Hoekster J.A.
Oh, Hoekster, yes.
With Judge Botha, Judge Grofskov, Judge Extian, and Judge Howie. But the judgment is penned by Judge Hoekster. Another strong bench.
Indeed.
Having heard arguments in the matter on the 7th November 1994, this court delivered its judgment on the 30th November 1994. The second appellant's appeal against his conviction for murder in count 1 was dismissed. His appeal against the sentence of 5 years imprisonment on counts 3 and 4 was likewise dismissed. What remained to be decided was the matter of appeal against the sentence of death imposed on each appellant on count 1. In respect thereof, this court stated in its judgment that while it was disposed to confirm the 2 death sentences, it was nevertheless appropriate, for reasons set forth in Makwanyana, to defer consideration of the appeal against the death sentence pending a ruling by the Constitutional Court upon the constitutionality of the death sentence. In other words, what the learned justices are saying, that had it not been for Makwanyana, etc., they would have been disposed to confirming the death sentence.
Yes. But there were some sentencing remarks as well by the Supreme Court of Appeal.
Yes, I'm coming to them. I am coming to them. Yes. Accordingly, this court ordered as follows: the final disposal by this court of the appeals of both appellants against the death sentence imposed upon each of them in respect of their convictions for murder on count 1 is postponed to a date to be determined by the registrar of this court after consultation with the Chief Justice. And the Constitutional Court, having since ruled that a sentence of death is unconstitutional and invalid, it is now necessary to set aside the sentences of death and to substitute, therefore, such punishment as this court considers proper. In this connection, counsel on both sides have submitted to us written heads of argument. Counsel for the appellant submits that in each case there should be substituted a sentence of imprisonment for 12 years, such sentence being antedated to 15 October 1993. On the other hand, it is contended on behalf of the state that in respect of count 1, each appellant should be sentenced to imprisonment for life. I consider that the state submission must prevail. The circumstances of the case are described at some length in the judgment of this court delivered on the 30th November 1994 and do not require repetition here. And here are the sentencing remarks. This was a cold-blooded assassination of a defenseless victim. The crime of the two appellants was a calculated one. Well in advance of its commission, careful preparations were made both for the murder and for the concealment of the identity of its dastardly perpetrators. The atrocious crime demands the severest punishment which the law permits. Those are the remarks. And the ladyship will notice that the justices use very, very strong language. They describe the act and the perpetrators of the crime as dastardly perpetrators.
It was a heinous crime.
Absolutely. And they describe the crime as an atrocious crime, which deserves the severest punishment. So, our submission, therefore, having read all this, is that we submit that this was no ordinary murder. It was an assassination which was calculated to lead to mass bloodshed.
How many years do you suggest for this type of crime? How many years imprisonment? Should it stay life imprisonment before someone is, Mr. Walus may get parole? It's now been 23 years.
Yes.
But your argument is that in view of those sentencing remarks, and there's no question that this was for the whole of South Africa,
yes,
a heinous crime, a
yes,
crime that could have disrailed
yes,
our new democracy.
yes.
I'm just trying to understand that how many years for such a person before such a person may be considered for parole?
My lady, I personally cannot answer that question, but the ladyship will recall that when we argued this matter, I referred to the matter of Seran.
Yes.
The person who had assassinated Senator Robert Kennedy way back in 1969. In fact, there's an uncanny similarity to the facts, because Seran was actually an immigrant to the United States, as Walus was an immigrant, and they were both sentenced to death. And before the death sentence could be put into execution, both jurisdictions at South Africa and California outlawed the death penalty. So they were, sentences were converted to life in the case of both. Now, Saran has been in custody now for 48 years.
Do we know what the legal framework in California is to consider parole?
Lady, I haven't studied that, but they go through various parole boards and parole hearings similar to South Africa. And I would believe that the principles, being a developed country, are analogous.
It will, however, be difficult to compare the two if one do not have the legislative framework.
Yes.
But I hear what you're saying,
yes.
that I asked you how many years,
yes.
and you said 48 years in
yes.
that instance.
48 years for Saran. And in February this year, he went for his 15th parole hearing, and it was turned down. And the parole authorities ordered that a new profile should be presented 5 years' time, in other words, 2021. So, when he's about 53 years, serving 53 years, he'll go before the parole board. I'm just answering your ladies.
No, I do appreciate that.
That this does happen. It's not up to me really, but certainly it's up to the decision maker, who is the minister in this case, to determine that. And unless it is found that what he did was unlawful, or was irrational, or was so unreasonable that no reasonable
minister,
decision maker or minister could arrive at that, or vitiated by any other factor like malice, bias, etc., etc.
undue influence and so forth.
Yes. Our submission really on that is that none of those factors apply. In other words, we say the decision was not irrational. We say that the decision was not unreasonable within the meaning of Section 628 of PAJA, and a ladyship's finding that the decision was irrational and unreasonable was a misdirection which ought to be tested by the appeal court. That is really our main submission. But obviously there are subsidiary submissions which appear in our application for leave. The first one is really the one I have been dealing with now.
That would be in paragraph 2.2. That's the one, reasonable and rational. Yes.
Well, firstly, Milady, the first one, that the Honourable Court failed to have proper and sufficient regard to the importance of the remarks made by the trial court and the Supreme Court of Appeal at the time of imposition of sentence on the applicant. And we say that the court accordingly erred in finding that the applicant complies overwhelmingly with all the criteria for placement on parole, and that the decision of the first respondent not to place the applicant on parole was not reasonable and rational and fails to be set aside. That is what I've been dealing with now. A second ground, we say the court erred in making the orders held that the nature of the crime committed by the applicant, taken together with the remarks made by the trial court, is just one of 7 factors which the first respondent was required to take into account for purposes of this decision. We say the misdirection there is not elevating, in the particular circumstances of Mr. Walus, the nature of the crime and the remarks to one of utmost importance. Yes. That is the point that we're making.
You've referred me to the case law for that.
I beg your pardon?
You have referred me to the
Yes.
case law for that submission.
Yes. Darby Lewis, the socius criminis of Mr. Walus. Now, the ladyship also held that the first respondent's view that the nature of the crime committed by the applicant and the remarks made at the time of imposition of sentence outweighs the positive factors in favor of his placement on parole entails that the first respondent considered the period of incarceration served by the applicant as inadequate punishment for the crime committed by him. The decision of the first respondent not to place the applicant on parole was not reasonable and rational and falls to be set aside. Then we say a ladyship erred in concluding that the decision was not reasonable and rational. I've dealt with that, lady. And we also say that a ladyship did not have proper regard with the need to retain a distinction between the appeal and review processes, and in having conflated the principles applicable to appeal and the review processes, and in substituting the ladyship's value judgment for that of the minister regarding the placement of the applicant on parole, and thereby we submit that the ladyship infringed the doctrine of separation of powers. Our authority, the lady, for the last 2 submissions is the case of Beto Star. It's in our heads, the heads that we filed when we're arguing this matter, and that would be footnote 18.
Just give me the
citation.
Yes, again.
Yes. Beto Star Pty Limited. This is Minister of Environmental Affairs, 2004, Volume 4, SA, 490 Constitutional Court, at paragraphs 44 to 49.
Thank you.
I think that decision also appears, if I'm not mistaken, in the bundle that was put up by the applicant.
Yes, no, thank you, Mr. Moran.
Yes. The ladyship will find it there. Now, coming to the guidelines, lady.
Are we now dealing with the third ground of appeal, actually second?
Well, I've dealt with the second. I'm now dealing with the third. Yes.
And that pertains to the guidelines.
Well, it actually refers to the factual findings that her ladyship made with regard to what the minister had regard to or did not have regard to. We say the following. It is stated in the answering affidavit deposed to by the respondent that for purposes of his decision regarding the placement on parole, due regard was had to a number of factors.
Yes.
There are 6 of them. First one being the behavior.
Yes, I have read
Yes.
this portion of your application,
Yes.
and then the conclusion is that the court misdirected itself.
Yes.
That is 3.2.1, yes.
That's right. That's right. That the court misdirected itself in finding that the facts pertaining to the positive factors in favor of the placement of the applicant on parole were neither mentioned nor discussed in the answering affidavit deposed to.
That is not correct, Mr. Morani. I did state in my judgment it was mentioned but not discussed.
The lady, if can
Just direct my attention to the paragraph and the discussion.
Paragraph 13, lady. Paragraph 13 of her ladyship's judgment.
Although the factors to be taken into account are mentioned in the minister's affidavit, so to state that I found that the minister did not mention the factors is not correct.
This is how it reads, lady.
Yes.
How it reads. It's and the relevant part is the last sentence. Okay? It is not clear from the minister's affidavit to what extent he considered the other applicable considerations, although the factors to be taken into account are mentioned in the minister's affidavit.
Yes.
The facts pertaining to each of the factors were neither mentioned nor discussed.
So do you see the difference? The minister did mention the factors, but the facts underlying these factors were not mentioned and not discussed. Do you see the difference?
Well, milady,
But yes, you may carry on.
I think the best way of dealing with this, lady, is to look at what the minister said.
Yes.
And this is to be found in page 212
Page 212.
of the record, yes.
Yes.
Yes. When deciding whether an offender should be placed on parole, a due cognizance is required to be taken inter alia of 1, the behavior and adjustment of the offender
Yes, those are the factors to be taken in account.
Yes.
And that were mentioned, or was mentioned by the minister.
I'm coming to that.
Yes.
I'm coming to that. The multidisciplinary programs attended by the offender within the correctional center aimed at his or her rehabilitation, the availability of support systems to the offender on being placed on parole, the contents of social worker and psychologist reports regarding the placement of the offender on parole, whether the offender has a fixed address which can be monitored on his or her being placed on parole, the offender's criminal history, and then it goes to deal with the nature of the offense, etc. Then the lady in paragraph 14.6.
Paginated page.
Page 223.
Yes.
Page 223. Paragraph 14.6. For purposes of my decision not to place him on parole, I took into account as positive factors in favor of the placement of the applicant on parole the behavior and adjustment of the applicant during his incarceration, brackets, as attested by his clean disciplinary record within the correctional center. That's one of the factors which is mentioned. The multidisciplinary programs attended by the applicant aimed at his rehabilitation, the contents of the social worker and clinical psychology reports regarding the placement of the applicant on parole,
Yes.
the availability of support systems to the applicant, together with his offer of employment in the event of his being placed on parole. In other words, all these factors were taken into account.
Although the specific facts were not set out as the facts pertaining to the nature of the crime was set out. So although those facts underlying these factors were not set out, I hear what you're saying. It was still taken into account.
Yeah, they were taken into account. That's the important thing. That's the important thing, that they were taken into account. Whether or not they were set out, Syria team, the important thing, milady, is that they were taken into account. That's really the important. And
Yes.
then
Yes.
Yes. Now, on page 224, 15.3, it's the guidelines contained in the parole board manual, in particular, criteria for parole selection contained in the chapter, the B order, which are quoted at pages 23 to 27 of the paginated papers, that refers to the applicant's paginated papers, were applied by me in the consideration of the applicant for placement on parole. Now, first one, the regard being had to the provisions of Chapter 6, etc., under the heading Nature of the Crime, the nature of the crimes committed by the offender, the remarks made by the court at the time of the imposition of sentence, and whether crimes took place in cold blood or impulsively must be taken into account when considering an offender for placement on parole. The Honourable Court is in this regard respectfully referred to paragraphs 2.5 and 2.6 above. And 2.5 and 2.6 Ladies, 2.5 relates to the provisions of Section 63(1) of the old Act. It says, in terms of the provisions of Section 63(1) of Act 859, which finds application to the placement of applicant on parole by virtue of Section 136(1) of Act 111 of 98. The decision maker is, for the purposes of the decision whether to place an offender on parole, enjoined to have regard, in quotes, to the nature of the offence and any remarks made by the court in question at the time of the imposition of sentence. And then the next paragraph 2.6, my lady, deals with the Darby Lewis case and the question that the nature of the crime and the sentencing remarks
The
are
most important.
utmost important for a proper decision on the placement of applicant in parole. Then 2.6.1.3 are all the matters that I've already dealt with relating to the nature of the crime and the sentencing remarks. Then 15.3.2 on page 225.
Yes.
In terms of the provisions of Chapter 6, etc., D, of the order under the heading Behavior and Reaction to Treatment, the behavior and adjustment of the offender during his or incarceration, together with the multidisciplinary programs attended by the offender within the correctional center aimed at his or her rehabilitation, are to be taken into account when assessing an offender for placement on parole. Then the important section, these positive factors in favor of the placement of the applicant on parole were duly taken into account by me when considering him for placement on parole. In other words, they were taken into account. 15.3.3, 19F of the B order, under the headings Domestic Circumstances and Employment Opportunities after placement, regard is to be had to whether an offender will have a fixed residence, as also whether he will be capable of obtaining employment in the event of being placed on parole. For purposes of my decision regarding the placement of the applicant on parole, due regard was had by me that he intended living with and had been offered employment by his brother in the event of his being placed on parole. Now, lady, one wonders what more the minister should have said about this particular, what facts should have...
No, I hear what you're saying, yes.
As what is. Due regard, 15.3.4. Due regard was likewise had by me to the reports of the clinical psychologist and the social worker as contained in the record of proceedings filed in terms of the Rule 1553(1)(b with regard to the placement of the applicant on parole, as also that he was a first offender for purposes of 19C. In other words, what we are saying, lady, is that the minister took into account all the positive factors.
Properly took into account.
Properly. That is so. That is so. And and when the judgment says otherwise, we submit, lady, that was with respect a misdirection.
Thank you. Mr. Murani, are you going to move to another point at this stage?
I'll move to another point.
Yes. Now, I'm asking because it is the tea time break.
Oh.
And
yes.
The court will adjourn until 5:30.
Well done. Look at that. Hey, Murenaka. Hey, yeah, well done. Yo.
Yeah. No. She's trying to relate.
Yes, I can see. Oh yeah. Oh yeah. No, that's true.
No. Let me just finish up my preparation.
Yeah.
Because
No, that's fine.
I'm not going to be too long.
Yeah. You've broken the back of your work.
Yeah.
Where is Mr. Pester? Is he out?
He's gone for a smoke.
Or a puff?
Yeah, for a
Should be well advised.
I know, man. I know.
Okay, okay. Okay.
Gentleman is.
We're waiting for one country.
Finished motion. I know. Judge is waiting for him.
nie lang staan in die hof. Raise een kort Sukumani.
Mr. Warani.
Lady, please. I was about to move on to a point which relates to orbiter. That's paragraph 4 of the grounds. I shall not belabor that point. It's the point that relates to restorative justice. But I think it's common cause that the decision was not based on that. So whatever is said in that regard, I think will be probably regarded as obiter.
Yes.
So without abandoning it, I just mention it.
Yes.
I don't have to deal with it. Then that would be paragraph 4 and 5. Then I come to paragraph 6 of the notice. We state that section 65.5 of the old Act is the empowering provision for the placement on parole of offenders who are sentenced to life incarceration prior to the 1st of October 2004. And the section provides as follows: 5. Upon receipt from a parole board regarding a prisoner who has been sentenced to life imprisonment, the minister shall refer the matter to the National Advisory Council, which, after considering the report of the parole board and having regard to the interests of the community, shall make a recommendation to the minister regarding the placement of the prisoner on parole. And we state to the next subparagraph that section 65.5 of the Act does not make provision for a recommendation of the parole board to the minister regarding the placement. That section provides for a report from the parole board, in other words, the profile report. We further state that the recommendation of the first respondent provided for in 65.5 regarding the placement on parole is the recommendation of the National Advisory Council, in other words, not of the parole board.
And the second respondent is the chairperson of the National Council for Correctional Services.
That is so, my lady, that there is an error which runs through the judgment, and that error, I think, starts right at the beginning of the judgment. Yes. I think it's paragraph 2 or 3 of the judgment. I can just find it. Oops. Which says it correctly describes the second respondent. Okay. It says the second respondent is the chairperson of the National Council for Correctional Services and deals with the third respondent and the fourth respondent.
Yes.
But elsewhere in the judgment, and then it says only the first and second respondents filed an answering affidavit and were represented at the hearing of the application. It's actually only the first respondent that filed an answering affidavit.
Second respondent did not oppose.
I beg your pardon?
The respondent did not oppose the relief claim.
No. The second respondent did not, and in fact, the second respondent was actually not involved in the proceedings. But as I've indicated, lady, from paragraph 21,
Yes.
there is reference to a report by the second respondent.
Which is not correct.
I beg your pardon?
Which is not correct.
Which is not correct, yes.
Whose report is that?
I beg your pardon?
The report referred to the judgment. Whose report is that?
The parole board,
Parole board.
not the second respondent.
So the recommendation by the, just get that again, the National Advisory Council
Yes.
was never involved.
No. It's common cause that the National Advisory Council was never involved, but the judgment seems
But
to...
the section then states that the minister shall refer the matter. Did the minister in this instance not refer the matter?
No, my lady, because of the judgment in Van Vuren, which held that with regard to those offenders who were sentenced before a certain date, 1st of March 1994, their profiles don't need to go to the National Council.
In other words, although section 65.5 refers to prisoners who has been sentenced to life imprisonment, it does not refer to prisoners that were sentenced prior to 1 March 1994.
Well, it speaks in general, but in terms of the Van Vuren judgment, it does not apply to persons like Janusz Walus. So yes. That, lady, there are two Van Vuren judgments. There's the one which deals extensively with everything, but then there's a shorter Van Vuren judgment which deals with this particular matter. Because at that stage there was uncertainty whether those people who were sentenced before the 1st of March 1994 were subject to decision by the National Council. So that particular decision cleared the matter and said those are not subject to...
Just give me the reference of the second Van Vuren matter again.
It's an unreported judgment.
Unreported.
Yes. But
Should form part of the authorities that you referred me to during the hearing of the application.
yes. We shall lay our hands on it, and a ladyship will obtain a copy of that second Van Vuren judgment. In any case, it's between the parties, it's common cause. Yes. So
all the parole board does, it refers the profile to the minister.
yes.
And then it is in the minister's discretion.
Yes. For certain people. For others who were sentenced after that date, but before the 1st of October 2004, some before the 1st of July 2004, their matters have to go to the NCCS. So
the
lady,
letter that I refer to in the judgment, is that from the parole board?
yes. It's from the parole board, but a ladyship referred to that as the National Council of...
What is the meaning if the parole board simply places profiles before the minister? What is the meaning of the last paragraph? That, let me just get that paragraph. It reads, has taken a decision or has decided.
Milady, the parole board is simply acting in terms of the provisions of Section 65(5).
It has come to a decision to recommend the profile. It is actually totally wrong because there shouldn't be any decision whatsoever, according to the argument before me.
Yes, that is correct. That is correct, because what the parole board does in terms of 65(5) is to compile a report.
Whether this sentence I should not take any recognition of because it's incorrect.
Yes, that is so. That is so, Milady. And to the extent that her ladyship referred to that as a recommendation by the parole board, which obtains its authority from Section 65(5), we submit that.
It's not correct.
It's not correct. That is it.
I consider it another favourable factor, the fact that the parole board has come to a decision to recommend the profile, but that will not be a positive factor. Although it is stated that the parole board did recommend.
Well. A lady...
Pro non scripta shouldn't have any regard to that.
Lady will also recall that in the same report there were words to the effect that the matter was for future profile.
Yes, I recall there was a form that was not signed or completed, but in any event, the letter that I referred to, that is a summary of the conclusions. So is it your submission that the parole board then got it wrong entirely?
Yes. In fact, lady, on page 8
yes.
Of
the record.
Rule 53(1) record.
Yes.
Where it says placement recommendation, it says further profile.
By whom is that signed?
That one is signed by Mr. Senegal, J. Senegal.
And who signed this letter? The letter with the recommendation.
What I'm saying at this stage, milady, is that there's on page 8 there's provision for two signatures. The first one is
Mr. Senegal, yes.
Yeah, for the case management, chairperson of the case management.
Yes.
And then there's provision for another person, and that one is not signed.
Yes.
Although the words...
So who has signed the letter that states that it is recommended? Come to a decision to recommend a profile. By whom was that signed?
It's signed by a certain Mr. Maimela.
On behalf of?
Well, it's signed by somebody apparently on behalf of Weeks. That appears, the lady, to have been signed by Mr. Maimela, the chairperson of the parole board, on page 4.
And I would imagine that the chairperson of the parole board will have more authority than a certain Mr. Senekal. But be it as it may, yes.
Yes. In any event, the point that we are making, the lady, is
it's not a positive factor, and the Act does not make provision for that.
That is so. Now, so we therefore say, lady, paragraph 6.1.2,
Yes.
that the Act does not make provision for recommendation, and 6.1.3 recommendation to the first respondent provided for in 65.5 is the recommendation of the National Council, and says 65.6, the Act provides that the first respondent may, after considering such recommendation of the second respondent, authorize the placement of the offender. And then we refer then to the Van Vuren judgment in 6.1.5,
Yes.
without citing it. The Constitutional Court has held that the recommendation of the second respondent, provided for in Section 65.5 and 6 of the Act, does not find application to offenders who were sentenced to life incarceration prior to the 1st of March 1994, and that would apply to
Mr. Walus.
That is correct. Accordingly, no recommendation by the second respondent was made to the first respondent regarding the placement of the application of the applicant on parole. Then we further refer to the facts, where we say the recommendation of the parole board contained in the profile report, which Section 65.5 of the Act does not make provision for, was that the applicant not be placed on parole by way of a parole board having recommended a further profile. That's what we say.
Yes.
So the submission on the part of counsel for the first respondent at the hearing of the matter was that all applications for parole of offenders sentenced to life must be referred to the minister by way of parole board submitting the profile report provided for in 65.5. The submission was not that all applications for parole offenders sentenced to incarceration must be recommended to the minister. So we then submit that her ladyship misdirected herself in the three respects mentioned at 6.2.1, 6.2.2, and 6.2.3, and also 6.2.4. Then in the next paragraph, my lady, we refer in particular to the Barnard decision, and we say that in certain respects, her ladyship's judgment is not compatible with that of her ladyship, acting Justice Gately, as she then was. Basically, my lady, those are our submissions.
But in which respects?
I beg your pardon?
The paragraph simply states that a judgment in causa is incompatible with the judgment, and you just addressed me, or you stated that it's in certain respects. In which respects?
Well, one respect which comes to mind, lady, it's the treatment of the issue of restorative justice.
Oh, yes.
In particular, that one.
Mr. Morani, I notice from your application that let me rather put it this way. You did not, the fact that I made a substitution order,
yes,
that is not attacked.
Lady, I think we are relying very strongly on the grounds that we...
Now, I just want to make sure, because if I do grant leave,
yes,
the Act states that I must indicate specifically on which issues I grant leave. So should a court
yes,
of appeal agree with my judgment, then the substitution order is not an issue. Well, not according to your application.
My lady, I think ex abundante cautela, although that is not raised in the application.
And you are confined to your application.
That is so. I suppose, my lady, we are probably so convinced of the
the other grounds
of the validity of the other grounds that we thought it was not necessary to raise the question of substitution.
Yes.
Yes.
Anything further, Mr. Morani? Anything further?
No, except that the costs obviously should be costs in the appeal.
I noticed that you pray for appeal to the full bench of this court.
Yes.
Is that still your stance?
Yes. That seems to be the default position in terms of Section 17, subsection 6 of the Superior Courts Act.
Let's see. So there's no question that involves question of law of importance and so forth. This is just a straightforward normal appeal.
Yes.
Thank you.
Yes. As a court pleases.
Mr. Du Plessis.
May it please you, my lady. Lady, I think I should deal with ground 6 first and clear all the confusion up for your ladyship. But before I do that, my lady, perhaps I should just hand up to your ladyship what we prepared for purposes of assistance to your ladyship in this matter. We prepared heads of argument.
Thank you. That will indeed be of assistance.
And I beg leave to hand that up to you together with a copy of the Van Vieren case.
Thank you.
Which will be quite important. Now, my lady, the heads of argument deal with not only the application for leave to appeal, but also the Section 18.3 application, so we can ignore that for the moment. If you'll just bear with me for 1 minute. Lady, now, we've also made copies of certain authorities we refer to in the heads of argument, which I beg leave to hand up to you for your assistance. Milady, the whole issue pertaining to the legislation. This legislation is extremely difficult to follow, and it's extremely difficult to understand the legislation, how things happened one after the other. Now, if I could refer you, and I'm now going to deal with ground 6 first because I want to clear that up and get it out of the way.
Section 65.5 of the Act.
Section 65.5 of the Act. What I handed up to you was the section that was handed up to you during argument, and I don't think we addressed the issue maybe quite clearly in argument because it's common cause between the parties, and we work so much with this that we perhaps thought that you were with us, whereas there seems to have been some confusion. Lady, if you look at section 65.5, you'll see the note underneath that says NB. Subsection 5 has been substituted by section 9D of the Parole and Correctional Service Supervision Amendment Act 87 of 1997, a provision which will be put into operation by proclamation. Now that is 65.5 that you see here.
Yes.
Before this there was a different provision, 65.5.
Yes.
And I'll come to that. This provision became applicable, I'm not sure of the date, but after 1997. The issue in the Van Wyk matter was whether the previous 65.5 was applicable to Van Wyk, who fell in the same category as the applicant in this matter, or whether the amendment, the later amendment after he was sentenced, became applicable to him. So in the old dispensation, before this section was brought in, the parole board made a recommendation directly to the minister. And it is a recommendation.
Parole board made a recommendation, yes.
Directly to the minister. That's a section that was applicable in 1993. Then this section became applicable in 1997 or shortly thereafter. I'm not 100% sure when that was. My attorney could perhaps look at the date and just give me the specific date. So what happened was they changed the system later on in the 1990s to say, no, the parole board must give it now to the minister must refer it to the National Advisory Council, and then it must come back to the minister. But if you look at the papers in this case, it was common cause between the parties, and if you look at the answering affidavit, common cause between the parties that it was in fact the parole board that made a recommendation to the minister in terms of the old 65.5.
And the old 65.5 is not before me.
It's not before you. But it's referred to in the Van Vieren decision. And that's why it's important to go to the Van Vieren decision. If you turn in the Van Vieren decision, and perhaps I should take you through the Van Vieren decision also as a comparison to this matter. Because if you look at the Van Vieren decision, paragraph 5, the applicant, Mr. Van Vieren, was convicted on 13 November 1992 on counts of murder, robbery with aggravating circumstances and theft. That's the exact date when the applicant in this matter was sentenced. Exactly the same date. This application was brought, my learned friends disagree with me, but I verified it yesterday in the papers. This application of Van Vieren was brought in 2010, already before the Constitutional Court. I'll check the date, my lady, my learned friend.
Well, if one had regard to the case number, it's 07/10.
Sorry, it's 30 November 1992. He was, the applicant was sentenced in 1993.
Yes.
30 November 1993, I think, but it's the same. It's the same date. It was 30 November. I just got confused with the dates.
Yes.
But the fact of the matter is, they more or less were sentenced at the same time. This man is out of jail long ago. And there's reference to another case here of a Mr. Plonk, who got out before Mr. van Vuren.
But it appears, and I do not want to detract and...
No, I just made that observation whilst I'm going through this judgment, because it's interesting to read this judgment in the light of this application, to understand the time difference between the applicant before you and people like Van Vuren and Plonk, who were dealt with by the Constitutional Court long ago in 2010. And here we are in 2016, and the Minister in this matter says the applicant should still remain in jail.
But if Counsel Mr. Morani is correct that the nature of the crime and the sentencing remarks is of the utmost importance...
I'm coming to that. Just bear with me, please.
Yes.
Let me just finish this one point. If you then turn in the judgment to paragraph 24, the legislative framework and policies, and then turn to paragraph 28.
Yes.
Paragraph 28 reads as follows. As of 1 August 1993, in terms of Section 21 of the Correctional Services Amendment Act 1993, the whole of Chapter 6 of the old Act was replaced, with the result being that Sections 61 to 65, and in particular Sections 63 and 65 of the old Act as amended, now became relevant to prisoners who formerly fell to be governed in terms of the former Section 64. Section 65 related to the release of prisoners and the placement of prisoners on parole. A prisoner was entitled to be released upon the expiration of the term of his incarceration in terms of Section 65.1. Section 65.5 dealt with the possibility of a prisoner being placed on parole by the Minister upon recommendation of the Parole Board, and after having regard to the interests of the community. And if you look at footnote 49, it says this is the Parole Board, as defined in Section 4 of Act 68 of 1993, which came into operation on 1 August 1993. In terms of Section 65.5 of the old Act, the National Advisory Council made recommendations to the Minister regarding the parole of prisoners sentenced to life. It is noteworthy that neither subsections 5 or 6 of that section made reference to any period after which a prisoner serving life incarceration could be considered for placement on parole. However, as will be pointed out later, the departmental release and placement policy entitled offenders sentenced to life incarceration to be considered for release after various minimum detention periods. Now,
I just want to make sure, is it on page 24, footnote 30, that refers to the old section?
Paragraph,
Is it on page 24 of the judgment, footnote 30? No, it can't be.
No, that's the section
50.
65. That's the section 65 that we have
today,
that you have before you. Footnote 31 says these sections were amended by the Parole and Correctional Supervision Amendment Act 1997, which came into operation
on... Footnote 31.
Sorry, my lady?
Footnote 31 on which page?
That's on page 24.
Yes.
That's the crux of the matter. Sorry, I left that out. These sections were amended. That's now 65.5. Were amended by the Parole and Correctional Supervision Amendment Act 1997, which came into operation on 1 October 2004. That's the one that you have before you.
Yes.
The scheme of the 1997 Act was to empower the Parole Board, in respect of offenders sentenced to life incarceration, to submit to a court which sentenced the prisoner a report with recommendations on the possible placement of the prisoner concerned on parole or on day parole. Now, the point I'm trying to make here, my lady, is previously, as I understand it, in the previous dispensation, the recommendation was made directly by the Parole Board to the Minister. It's changed in terms of this section 65.5, which was promulgated in 1997, but which only came into operation in 1 October 2004.
It seems to me it is indeed common cause that this section is not applicable.
It's common cause that the section is not
And then
applicable.
it's
It's common cause that the parole board makes a direct recommendation to the minister. It's common cause.
So there need to be a recommendation.
It's
does
not
the parole
common cause.
board-
It's not common cause that it's a recommendation.
I beg your pardon?
It's not common cause that it's a recommendation. We say it's a recommendation. They say it's not a recommendation. We say it's a recommendation as a result of what is said in the Van Vieren case, and in particular, so just bear with me. If you just bear with me. In particular, paragraph 28 of the judgment.
Yes.
The third line from the bottom, section 65.5 dealt with the possibility of a prisoner being placed on parole by the minister upon recommendation by the parole board. And that was the parole board, if you look at footnote 49, that came into operation on 1 August 1993. And then it says, the sentence goes on, in terms of section 65.5 of the old Act, that refers to the 1997 65.5. The National Advisory Council made recommendation to the minister. So the court draws a direct distinction between the two sections, 65.5, and it says the one is the National Council makes a representation, the one says the minister, the parole board makes a recommendation. We were all at Eden that the parole board sent the set of documents to the minister. The minister acted thereupon. We analysed the report saying that it's a recommendation, etc. We submit that it's still a recommendation and your finding is 100% correct. They tried to persuade you that it's not a recommendation now because they are referring in their argument to the 1997 formulation.
But had the parole board, in terms of the previous section, was there an obligation on the parole board to automatically forward the profile to the minister?
It's never been clear from the Act whether the word recommendation means that it's a decision that they must make or not. It's never been clear. As I understand it, it's been the practice that only positive, but my attorney, it seems to me he's not supporting me. He says he doesn't know. As I understood it, it's the practice, but I can't tell you.
Yes.
And whatever I say about that is not binding. But what I can say is a recommendation is a recommendation.
Well, a decision was taken.
Yes.
If it's a mere automatic procedure, then decision does not come into play.
Correct. Then it's just a set of facts that are collated and put before the minister.
Yeah. But here in this document, the report, it's clearly stated, has taken a decision to recommend.
Correct. Now, the question is, my lady, what is the success on appeal that's going to flow from this? The fact that you incorrectly referred to, and we cited incorrectly the National Council, that's our mistake. We should have cited the chairperson of the parole board. That you incorrectly referred to the one person instead of the other, is that going to be the prospect of success on appeal here? So we submit that you can just as well take the reference to second respondent out and put in a reference to the chairperson of the parole board in respect of...
Principle remains the same.
The principle remains the same. Now, my lady, and in any event, let's accept for argument's sake that you were incorrect in relying on that recommendation as a positive factor. That's not going to be sufficient to have the effect of this judgment being overturned. So you have to look at reasonable prospects of success, not ground by ground, but in its totality. And in the totality, it's not going to make any difference.
Well, the test is whether a court, in view of all the facts, circumstances, applicable legislation, and so forth. Is there a reasonable prospect that another court will come to another finding?
Yes, that's the test. That's the test. Not that another court will find that your reference to the National Council
Must go to the crux of the matter.
Sorry, my lady?
It must go to the crux.
To the crux of the matter. It must be a whole new finding. And in fact, that another court will find that the applicant should not be released on parole. The effect of that other court's decision. It's not a question of rectifying your judgment in respect of this remark or that remark or an obiter remark if it doesn't have an effect on the order that you gave. It's about the order that you gave.
Yes.
They must show that there are reasonable prospects of success, that your order will be overturned. My lady, the question that you just now put to me about the utmost importance, please will your ladyship read the Darby Lewis case? Because one must look at that in context. That application was a review application that was brought before court without the record being available to the court. And the court said, well, I can't consider a review application without having the record. And in particular, of the utmost importance for the court to consider the review is the sentencing remarks and the facts pertaining to the sentence. It was in that context. It wasn't in the context of the court saying, well, for purposes of parole and my consideration of parole, the utmost importance is sentencing. So,
well, I'll have regard to that judgment again. It was not my recollection, and that's why I asked Mr. Murani, but I will carefully consider it again.
It was in that context, my lady, and unfortunately I didn't expect that to arise, otherwise I would have given you the copy. I think a copy of that judgment may be in the authorities' bundle that we handed to you, but it's a reported decision. Lady, in the heads of argument, if you turn to page 2, the application for leave to appeal, we try to give you as much as possible pertaining to reasonableness and rationality. And on page 2, paragraph 3, we refer to the definition of Hoekstra regarding rationality, and we've given you the pages out of Hoekstra where this is discussed. Now, my lady, the discussion is quite interesting because the question has arisen in certain decisions. His Lordship Mr. Justice Nugent in the AD has raised the question whether rationality and reasonableness can really be divorced from each other. Because the question is whether rationality is just not a bit more of a limited test as opposed to unreasonableness, which is a bit of a wider test. But at the end of the day, the question to be asked was left open by the AD, but you'll see the discussion in Hoekstra. The question is, isn't that really the same thing that you ask? The test really we submit when you look at reasonableness, my lady, to determine whether you were right or wrong. So from paragraph 8, there's a quotation that comes from the Barter Star matter. Even if it may be thought that the language of section 6.2h, if taken literally, might set a standard such that a decision would rarely, if ever, be found unreasonable, that is not the proper constitutional meaning which should be attached to the subsection. Subsection must be construed consistently with the Constitution, and in particular section 33, which requires administrative action to be reasonable. Section 6.2h should then be understood to require a simple test that an administrative decision will be reviewable if, in Lord Cook's words, it is one that a reasonable decision maker could not reach.
So that it's so unreasonable.
Yeah. And then her ladyship, Justice O'Regan, then put it very clearly, and one can apply this test, my lady. The nature of the decision, the identity and expertise of the decision maker, the range of factors relevant to the decision, the reasons given for the decision, the nature of the competing interests involved, and the impact of the decision on the lives and well-being of those affected are the things that must be taken into account. And then we analyse these principles from paragraph 10.1. We say when the nature of the competing interests are weighed, it is clear that the applicant's individual interests should trump the interests of the minister in the light of all the facts and circumstances, and in particular the time period that the applicant has already served his sentence. 10.2. The impact of the decision on the life of the applicant would be much more severe and detrimental than any impact upon the minister or government. 10.3. The nature of the decision is such an important decision pertaining to the human rights of a prisoner that any balancing act should weigh heavily in favour of the applicant. 10.4. The decision maker, namely the minister's expertise, is no different than the expertise of the court, both being lawyers. 10.5. The range of factors relevant to the decision indicate clearly that the positive factors applicable to the applicant for purposes of parole outweigh the nature of the crime. That's your finding. And the same observation is applicable to the reasons given for the decision. So, lady, having analysed those principles in Gato Star for unreasonableness, one comes to the same finding as you can.
The range of factors relevant to the decision, that is what was found by Justice O'Regan.
Yes, must be taken into account, and that's exactly what you did.
And in this instance, the range of factors, the argument is that really the utmost important factor is the sentencing remarks and the nature of the crime.
But it's not.
Yes.
It's not. Let me address that.
I'm just trying to follow, in view of this Constitutional Court judgment, to follow the argument. So although there are a range of factors to be taken into account, one should actually trying to put more emphasis. That's maybe the word.
When you deal with reasonableness, my lady, it's a balancing act. And these are the factors that you take into account. The question that bothers you, which I will get to, is their submission that the crime and the nature of the crime overrides everything else. But that's wrong, because that's not what parole is about. So let me perhaps, while I'm here, deal with that and set your mind at ease with that point, and then I'll carry on with the heads. May I ask you to go to the papers, the application papers,
Yes.
to page 121. Because one must, when you are now faced with the factors, and you ask yourself the question, how do I deal with these factors? One must go back to the policy guidelines. One must go and determine what is parole about. And the question is parole about how long this person must be punished? Or is parole about the rehabilitation of the offender?
Well, parole is still punishment.
It is still punishment. So it's about...
It's another form of punishment.
Good. So it's about the rehabilitation of the offender. And that, I'm going to try and point out to you where exactly you will see that. If you turn to page 127.
Yes.
Paragraph E, under criteria for consideration of parole guidelines. So these are the guidelines that were applicable.
Yes.
E says, the date of consideration is only an indication of when consideration for placement should commence. This date is delayed in the case of aggravating circumstances and unsuitability for parole. However, after the completion of 20 years of imprisonment, a recommendation must be made to the minister. It doesn't say he must be let out on parole, but a recommendation must be made to the minister, whether it's a good recommendation or a bad recommendation, because after 20 years, that's the guideline. After 20 years, it becomes now imperative to decide whether this person must be incarcerated further with reference to his rehabilitation. Then, if you turn to page 128,
Yes.
that's the most important one. Roman 1 under paragraph 2, the third paragraph. Doel van oorweging verplasing, omskepping, uitplasing, vrylating. Die oorweging van elke individuele geval behels 'n gedetailleerde ondersoek van inligting wat uit diverse bronne afkomstig is, wat 'n aanduiding van sukses buite die gevangenis kan wees. 'n Lae vlak van risiko vir die gemeenskap is nie die belangrikste oorweging nie.
Die Paroolraad moet egter oorweeg of die gevangene die maksimum voordeel van sy gevangesetting gekry het en dat sy hervorming en rehabilitasie bevoordeel sal word deur sy plasing onder omskepping in korrektiewe toesig of uitplasing op dagparool en parool. And then if you would turn to page 131, this is a memorandum setting out the reasons for parole and the background to parole and the question whether a parole system should be retained or not. It was a memorandum at the later stage of the National Advisory Council. It hasn't got a date, my lady, but it was common cause that this is also applicable to the applicant. Under paragraph 1.1, Roman 2, on all questions of parole, there are two conflicting considerations which are to be recognised and accommodated. On the one hand, the judicial officer imposing a sentence and the public generally do not wish to see its retributive and deterrent effect eroded by early parole. On the other hand, without a realistic prospect of the grant of parole, there is little or no incentive for a prisoner to become involved in rehabilitative programs or to conform to disciplinary rules. So, the longer you stay in prison, the less the deterrent and retribution aspect becomes, less important it becomes, and the more the focus is on the rehabilitation of the offender. And, lady, therefore, when one considers these factors, you have to keep this into account. And one has to, and that is exactly what you did. They are arguing that the most important factor is the crime and the sentencing remarks. You were right. It's not. It's a holistic consideration of all the factors. Lady, and then we say in paragraph 12, it's quite a useful judgment, the Ehrlich judgment, where the court, and that was His Lordship Mr. Justice Plaskett who gave the judgment, the court referred to three types of unreasonable decisions. I'm now back on unreasonability.
Yes.
Namely, those characterised by defect in the decision-making process, such as irrationality. And you can see there comes in again under unreasonableness. That's number one. Those taken in violation of principles governing the exercise of public powers, such as statutory or constitutional imperatives, and those that are unnecessarily disproportionate or onerous in their effects. Now, for a decision, the Minister's decision under these circumstances of the applicant was unnecessarily disproportionate and onerous in its effect. We submit that, and it was also irrational. So two of the three factors have been satisfied at the very least if one takes those principles into account. So your finding on unreasonableness and irrationality was 100% correct, and insofar as it is argued that the appellate division would take your judgment and then add a reference to the section in Parja that you referred to, that's ridiculous. That's not what an appeal is about. Lady, then we dealt with the specific grounds. The first ground, where they said that you didn't take the sentencing remarks into account. Lady, you did take it into account. We refer to the judgment, and we say it was common cause between the parties that the applicant positively complied with all the criteria for placement on parole. The only aspect that was taken into account by the Minister and that weighed against the applicant was the crime and the sentencing remarks. So on that ground,
common cause.
There's no reasonable prospect, lady. On the second ground, it's clear that the above court did not determine the issue by entering the merits in order to substitute her opinion on the correctness thereof, but that she determined whether the outcome was justifiable, rational, or reasonable, and you see it in your judgment. When a court considers the review of an administrative decision, it does not infringe upon the doctrine of separation of powers. And we see this argument continuously in the press and everywhere else, that how can a court interfere in the executive's sphere of work? How can a court review a judgment of the Minister? Even in the old abhorrent apartheid time, the court could review a minister's decision.
Well, that common law right has now been entrenched in our Constitution.
Correct.
So there's nothing strange about the principle. It is a principle of the Constitution of our law.
Yes. And we quote the Treatment Action Campaign judgment more or less in the same words. It's not a quotation in paragraph 20. The exercise of all public power is, however, subject to constitutional control. And it is the duty of courts, if called upon to do so, to determine whether or not power has been exercised consistently with the requirements of the Constitution and the law. That does not constitute an infringement of the doctrine of separation of powers. And we've seen that with the recent Constitutional Court judgment about the Nkandla matter. It's even Parliament's decisions were reviewed and set aside.
Well, that's check and balances. Otherwise, the executive would have a free hand.
Correct. So it's really tried wrong, lady. Then the third ground, my lady, is that issue about the factors and the facts. Lady, the point you made there, and perhaps I must take you back to the argument and why you said that. The argument was that the minister listed the factors and he dealt with some of the facts, but he did not come and say, this positive factor with these underlying facts I regard in this light. This factor with these positive facts underlying it I regard in this light. And so he simply threw in the affidavit a list of the factors, and then at later stages in the affidavit where it became necessary, he dealt with specific facts. And that's the point you made in the judgment. And that was correct. That was correct. It's not a question of you having said, no, he never listed the facts. The point that you made is that he did not discuss the factors with the underlying facts and their importance in his head for purposes of the consideration. Then, in respect of the fourth and fifth ground, my lady, that was the restorative justice issue.
It was never
in dispute.
And the applicants are not appealing against my order of substantiation order.
Correct. And you dealt with the observation you made, which was obiter, was in the second part where you dealt with the order that should be given, the substitution part. It wasn't part of reasons of the decision pertaining to review. So those grounds cannot succeed. So, lady, then the seventh ground is the last ground, and that is the one that the judgment is not compatible with the judgment in the Barnard matter, especially with reference to the recommendation of the second respondent and the procedure followed in respect of such recommendation. Now, we quoted the Barnard judgment. You can read the Barnard judgment, but what's important in this quotation is, and that was with reference now to the 1997 formulation of Section 65.5.
That is not applicable.
It's not applicable, but what's important is what her Ladyship Judge Keatley said. Given the statute of the National Council and the composition of its members, its recommendations must be taken seriously. The same can be said about the Parole Board's recommendation in this matter. The Minister cannot reject the Council's recommendations without good reason to do so. In circumstances where the Minister is unable adequately to explain his departure from reasons advanced by the National Council for its recommendation, it would be permissible to infer that the Minister acted unreasonably. And in that matter, she found that the Council didn't give reasons for the recommendation, so she couldn't rely really on the recommendation. So this is an indication of the court actually viewing the National Council's recommendations as something that a minister must take into account as a recommendation.
That's why I asked Mr. Mourani. The minister's decision must be taken within the empowering legislation. So the Parole Board, all the policy of the Parole Board, the criteria, all of that needs to be considered.
Yes. One cannot say they made a recommendation, but it's not really a recommendation, so I'm ignoring what they do. What do they do then? Are they then just an administrative clerk type of body that collates the documents and sends it through to the minister? Then the department could do that. What is their function? Their function is something different. Their function is to sit as an expert body who deal with these things, specifically with a view to see that parole is done on an equitable, fair basis to everybody.
It would almost seem, in my mind, that if the crime is of such a nature and the sentencing remarks is so important, and one knows this, in the present matter one knows what happened in our country, one knows the prominence of Mr. Hani, then there simply should not be any parole board hearings, because the other factors, seems to me, does not play a role.
Well, if they are correct in these submissions, my lady.
I'm trying to make sense of this. If that is the test, then this whole parole board hearings, what role does it play?
Doesn't make a difference, because if you committed a murder, then the minister is the person who ultimately decides how long you sit.
Whether you've complied with all the other factors,
doesn't make any difference. There's no goal to work for early parole. There's no goal for rehabilitation, as we've seen, is the focus. And at the end of the day, the minister is an arbitrary decision maker who decides, well, this murder was with a knife, this one was with a gun, so this guy gets out at 15 years, that one gets out at 17 years. This one killed a street child, so that's not so important, so he can come out at 15 years. This person killed Mr. Chris Hani, that's very important, he can only come out after 40 years. Where is the law going if that's the kind of application? And may I also make this submission, that to make submissions about the American system goes nowhere, because we don't know what the parole conditions of the American system.
Yes, but I think Mr. Marani simply reacted to a question that I posed.
He did, but he likes that comparison because he did it before. And I just want to illustrate to your ladyship that that's something that should be ignored, in fact. Lady, now, the question, I'm just reacting to some of the aspects that he raised. The question of justice and closure. Justice has been done here. Justice is still being done, even if this man gets parole. Because parole is not easy. There are conditions. You can't go anywhere.
I think that is one of the... but that was one of the policies of parole, where it clearly states it is still punishment.
Correct. In the policy documents you will find it, that it states specifically that it is still punishment. I'll try, when my learned friend replies, I'll try to get that specific...
I'm quite sure it was in my judgment, but in any event, it is not letting someone off the hook or...
Correct.
Still punishment.
Correct. It is focused on rehabilitation. If a person does everything correctly while he's incarcerated, he may get out on parole earlier because he has shown that he has been rehabilitated. Lady, and I made the submission, but the retribution and deterrence aspect becomes less and less important the longer he stays incarcerated, the more positive the factors are pertaining to his behaviour while he was incarcerated. If you'll just bear with me for a moment. And then, in this regard, lady, I want to take you back quickly to the Van Vuren matter, where the Constitutional Court itself dealt with this point. I want to take you to page 36, paragraph 51. I marked the whole paragraph, but we can start at the fifth line from the top. Evidently from the departmental release and placement policy, and that's the same one that is before you now. Parole has a restorative justice aim. It is aimed at the eventual rehabilitation and reconciliation processes of the offender, themes that underpin restorative justice. Importantly, all these interests must be balanced against those of the community, which include the right to be protected against crime. So here, the Constitutional Court does not even refer to the nature of the crime. It refers to rehabilitation, reconciliation, restorative justice, and then the right of the community to be protected against persons who committed a crime. And then if you turn to page 43, paragraph 67 of the judgment, the court said the respondents contend further that a balance should be struck between Mr. van Vuuren's interest and the interest of society in securing itself against the possible perpetuation of crime as a result of his early release. So that's the main focus, not the nature of the crime that he had committed. There can be no doubt that the interests of the victims in our society, where violent crimes are prevalent, indeed have particular cogency. However, the liberty of a sentenced offender, measured from the perspective of his or her eligibility to be considered for release on parole when that offender has reached the consideration date, should not be ignored. Mr. van Vuuren has served more than 15 years of his sentence. And then in paragraph 70, I conclude that Mr. van Vuuren has made out a case for his eligibility for consideration for release, placement on parole.
And this is a Constitutional Court judgment.
Yes. Ladies, so we submit that, taken holistically, if you take all the grounds into account, there are no reasonable prospects of success, and the application should be refused with costs, including the costs of due counsel. This is one aspect before I sit down, my lady. The application in terms of section 18.3 that we brought was an application that would even be applicable should you refuse the application for leave to appeal, because if we walk out of here and a petition is filed to the SCA, we're going to have to bring in a section 18.3 application.
Yes, I saw that the appropriate time to hear that application is when I want to give judgment in this application as soon as possible. Most probably on Thursday.
Oh, and then we can deal with that.
Yes.
As it pleases you.
To my mind, before I've decided on this judgment, then that might be premature.
As it pleases.
Mr. Mulindi, it seems that you will not need to address me today. I am going to give judgment in this application Thursday morning at 10 o'clock. And then if the application in terms of Section 18 of the Supreme Court Act proceeds, then you will have a turn.
That is so, my lady, then since we will address the court after a decision has been taken that from the current application.
Otherwise, it does not make sense to hear an application if there is not a pending appeal. Do you agree? Thank you. Mr. Morani, in reply.
The Van Vuuren judgment that has been handed up to your ladyship is the main Van Vuuren judgment. But there is another unreported Van Vuuren judgment which we shall endeavour to make available to your ladyship before in a day or so, which deals with the very issue relating to Section 65.5. I know because I was involved in both cases.
So you definitely have first-hand knowledge. Section 65.5, prior to the amendment, was there an obligation for the parole board to send profiles to the minister?
Yes.
So there wasn't the parole board did not have a choice.
Yes, no.
Not a choice.
Oh, it had to send the profile to the minister. That's correct.
And was there anything in the section that referred to a recommendation, or was it an automatic? It must go to the minister.
It was automatic, the lady.
So there wasn't the wording of the present section. Those words recommend was not there.
I'd really have to look at it. My recollection, but I obviously speak under correction, that it was similar in the sense that a profile had to be presented to the minister. May I just confer with my... My learned colleague says that the recommendation from day one has always referred to the National Advisory Council, not to the parole board.
Just say that again. The recommendation.
Yes. It was something that had to be done by the National Advisory Council,
So
not the parole board.
So the parole board merely presented profiles to the minister.
Yes.
And that would be the correct word in terms of the section.
Yes.
Could you kindly obtain me a copy of the section before it was amended?
We'll try. We'll try. This section has been amended so many times. For instance, the section that Melena Trend was reading to you, which refers to reference to a court, that existed for a very short time, and it was removed.
Luckily.
I beg your pardon?
Luckily.
Yes.
Otherwise, the courts would have been flooded with applications.
Absolutely. Yes. Now, where the question of separation of powers arises, lady, it actually arises in the very Battlestar decision, where the learned Justice O'Regan, referring to a judgment by Justice Scutts of the SCA, deals with the question of deference. The idea being that the courts should be slow to interfere with decisions, administrative decisions of administrative agencies.
Yes.
And in fact, that principle of deference is actually based on separation of powers.
Yes.
And that is really the point we are making.
Yes.
We are not saying that the court cannot set aside.
No, the court must be slow, and each matter must be evaluated on its own facts.
That is so.
But the separation of power, I hear what you say, does not mean in appropriate circumstances the court may... Yes.
Absolutely.
No, I agree.
That is where separation of powers, and this is in paragraph 46 to 47 of Battlestar.
Thank you.
Yes. Now,
is it still your submission, that the one factor is the utmost important factor?
Yes.
Why are there other factors at all? If a crime is so serious and the sentence remarks are so, like we have in the instant matter, I do not understand why there's a parole process then at all.
Well, the lady, cases differ. Cases differ. In in one case, a particular factor might weigh heavier than another factor. For instance, in the Barnard case, his criminal profile apparently weighed very heavily with the minister. In other words, that this was a person who had a history of criminality and who committed a murder while he was out on parole for another murder. So those facts, in other words, facts surrounding the crime and the sentencing remarks, they assumed greater importance. The minister refused to release him on parole, notwithstanding a positive recommendation by the National Council, and his decision was upheld by your sister, Kaiti AJ. So
maybe I'm just asking on a very logical level.
Yes.
That if one has a prisoner who's committed this serious offence, and it's a very serious offence, and the sentence remarks that's been made, put that prisoner one side and do not waste the state's time and money to put him through the parole process, because what's the purpose?
No, my lady. It's essential. It's essential because all the factors.
But all the factors are positive in this instance.
All the factors have to be taken into account. In other words, the positive factors, which the minister took into account, and the negative factors relating to the seriousness, the atrociousness of the crime, the fact that the highest courts in the land at the time said that he was deserving of the harshest or the severe...
No, but I think we're missing each other, Mr. Morani. Everyone in prison knows who's Janusz Walus. Everyone in the country knows. You agree?
Yeah.
Yes. So in view of the minister's stance that due to the fact that Mr. Janusz Walus very callously and in a horrible manner murdered Chris Hani, he should not waste the parole board's time, because everything is now positive. You agree? All the other factors are positive, but because of the type of crime and the sentence remarks, that is always, according to your argument, that's the utmost important factor. I'm just trying to think logically, why would the court or the state waste money to go through all of these processes if that's going to be the end result in any event?
Lady, when the state correctional services goes through this process, it does not know what the end result will be. And these processes are dictated by legislation. In other words, an offender, after a certain period, once he's eligible for parole, has to be...
no matter who you killed.
Has to be assessed for parole. And a decision can...
No, I hear what you're saying. If that is the utmost importance, then that is also always going to count against such an applicant who wants to apply for parole.
Not necessarily, milady.
At what stage, you mentioned 48 years, at what stage will this not count any longer?
The lady asked me that question, and I have another answer with regard to...
Now, I appreciate that. I'm just trying to follow the factors and why, if certain factors is of the utmost importance. And I think we've now canvassed this subject. Yes.
Lady, may I refer the ladyship to Section 73, 6,
Yes.
B, Roman 4.
Just as section 73.6,
B,
Roman 4,
Roman 4 of the new Act.
the new Act.
Yes, 118 of 1998, which deals with the release from correctional center and placement under correctional supervision, and it deals with length and form of sentence. The first subsection 1 says, subject to the provisions of this Act, a sentence offender remains in a correctional center.
Are those that you're referring me to now, is that applicable to the matter under consideration? I thought the old is, yes.
Lady, I'm just raising this in answer to your ladyship's question.
With respect of the factors.
No, in respect of even the length. The length.
Oh.
The ladyship asked me
Yes.
what would be an appropriate length, whether it was 50 years or 48. The point I wish to make is that the legislature has now decided on a benchmark.
Yes.
I know it doesn't apply.
No, I know.
But the benchmark, all the same, in other words, to test the reasonableness of the decision. Because in terms of the new Act,
Yes.
73, 1A and B, it says, subject to the provisions of this Act, a sentence offender remains in a correctional center for the full period of the sentence. And B, an offender sentenced to life incarceration remains in a correctional center for the rest of his or her life. But obviously it is subject to what?
Because I understood from the arguments that were presented to me during the hearing of this application that the parties agreed on when a person, although is sentenced to life imprisonment,
Yes.
At some stage a person may be looked at for parole. Eligible, that's the word.
That's correct.
Is that not the case?
No. We are saying the fact that an offender is eligible for parole does not imply that he or she must be released.
No,
on parole.
not entitled to, because if all the factors were negative, for instance, if a person decides, I'm not going to try and rehabilitate at all, I'm still committing murders in prison, or there are many factors, and obviously a person, and I think that's why the various factors must carefully be considered, because no one, and you're quite correct, is entitled to parole. There are certain factors that are taken into account. No, I take your point.
Absolutely. So the section to which I wanted to draw the ladyship's attention is this 73, 6b Roman 4, which says a person who has been sentenced to life incarceration may not be placed on day parole or parole until he or she has served at least 25 years of the sentence. So the point I'm making there is that the legislature deemed it reasonable not to release an offender who has been sentenced to life imprisonment until he or she has served at least 25 years of the sentence.
And from which date is that?
That is after the 1st of October 2004. In other words, everybody who has been sentenced after that date.
May not come into consideration for parole before they've served 25 years of
Yes.
their sentence.
That is so. The point I'm making, the lady, is that, firstly, by enacting that provision, the legislature, unless somebody brings that, applies to have that particular provision set aside as unconstitutional, the legislature cannot be presumed to have been unreasonable by enacting that particular.
No. But that particular section we are referring to, and I know in what sense we're referring to that, was not before. It was not before the minister when he took this decision.
Yes.
It's not applicable, if I can call it that.
Yes. Yes, I'm just talking about the
Yes.
length.
Yes.
The
No, I hear what
ladyship
you
asked
say.
me about length.
Yes.
I mentioned Saran, 48 years.
And now you're mentioning yes.
I'm mentioning what South Africa says for current offenders. So 25 years is not unreasonable. That is really the point I'm making.
I hear what you're saying.
Yes.
And that applies across the board.
I beg your pardon.
That applies across the
Yes.
board.
Yes. Yes. Learned friend has drawn my attention to the fact that in terms of the decision refusing release on parole, decision of the 10th of April 2015,
Yes.
which coincidentally it's the date on which he was murdered, 10th of April, but 1993.
Yes.
That the recommendation was that a further profile should be presented within 12 months, which would have been this month. It's just
Yes, the court processes do take time, and
I beg your pardon.
I say court processes do take time. So,
Yes.
but I take your point.
Yes. Those are our submissions.
Thank you, Mr. Du Plessis. There's something new that now arose in the 25 years.
Yes, my lady. Section 73. I want my papers back. I didn't want to give it to her.
Of the overall national figure.
A total of more than 6.6 million voters visited their voting station over the 2 registration weekends. This includes the 3,581,540.
22.
And it, eh?
22 of the papers.
Yes.
You will see that the time periods have been set out from 1910 in the old horrendous apartheid time. How long prisoners must be in jail. And from 1910 to 1956,
Yes.
for life imprisonment was 10 years prior to consideration for parole.
Yes.
From 1956 to 1959, 20 years. Then from 1959 to 1987, 10 years. Then from 1987 to 1994, 10 years. It says 10 years prior to consideration, but placement only in exceptional cases before 15 years. So one should actually say 15 years. Then 1994 to 1995, 20 years. And then from 1 October 2004, it has now become 25 years. So as
1 October?
1 October 2004. So in the apartheid years, my lady, the time before you could apply for parole was much less than in the new democratic South Africa. But whatever the case may be, South Africa, the new South Africa has a crime problem, and therefore it's necessary to do
Yes. Now, criminals must be punished, no doubt, in accordance with the severity of the crimes. But we are now looking at a parole, at the acts and the legislation that inform a decision.
Correct.
So there's no argument that crime must be punished properly. But we are now a step further. We're now at the parole stage.
Well, lady, the fact of the matter is that in respect of the applicant, a period of 15 years is applicable. If you subtract certain amnesties that were applicable, one gets to a period of more or less 13 years. That's applicable to the applicant. One cannot read the Act now in 2016 and apply it retrospectively back to 1993 to the applicant and then say, well, I apply the 25-year principle now onto the applicant.
And I don't think, to be fair to Mr. Morani, that is what he indicated. I hear that the nature of the crime and the sentence remarks remain an important factor.
But you asked him whether the 25 years is applicable across
it's not
the board.
applicable, yes.
And he said yes, and I just want to rectify that. It's not applicable across the board. The 25-year
across the board,
principle
yes.
is not applicable to the applicant, so one cannot take into account 25 years as some form of benchmark when you consider parole, taking into account 15 years as it is.
Thank you. As I've indicated, I will deliver judgment Thursday. It's the 14th of April, 2016 at 10 o'clock. Court will adjourn.